So, done.
Thank you.
Yeah.
4 minutes. But we have a legislature that is much more concerned with issues other than the economic.
What's Bernadette? Are you still there?
Or the schooling, or the healthcare. Other than
Bernadette, are you still there? Background noise.
Okay, I'm gonna hit stop recording on this one then.
He's a school superintendent, and
Hi, Josh.
hello, how are you?
You are co-host?
Also in text in other places. But what that's created is, of course, the population's growing. More services. And so they're all text structure.
Josh, do you know if your session is planning on being recorded?
I believe it is.
Emily? Hi. There we go. Is that better? Yeah. And I think we have everybody here. I see Stacy, and I see Rita, and I see Rachel, and I see David, I see Hyesook, and I see Alia.
Yes.
Good to go. We'll start in a couple of minutes, and I think we'll go in the order that you're listed in the session for this AILR LERA Best Papers sessions, and congratulations for submitting your work and having it accepted, and that's all very good, and we'll move on from here.
David, hello. Did you want to make me a co-host so I could share my slides?
How do I do that?
Just go next to my name and say make co-host.
I think we're all co-hosts, are we? I think
Oh,
we're
we
all-
are.
Yeah,
Oh,
you can definitely share your screen.
Yeah, you can show your
I
slides.
can? Oh, I can already? Okay.
I think so.
You okay if I go ahead and do that then?
Yes, let me say one other word too. We're going to try to keep your presentations to a max of about 10 minutes, given that we have 5 papers and an hour. Yesterday, I hosted a session where we had 2 papers, interestingly enough, so they got a little more time, but today a little less time. So let's wait 1 minute just for others to get on here who are planning on attending the session. And we'll take questions and comments. I guess we'll use the chat feature. So if anybody has a comment or a question, put it in the chat and I'll verbalize it to our presenters and we'll move on from there. There we go, Stacy. So we're going to begin this session, and once again, it's the LERA AILR Best Paper session. We typically do one of these at each program, and if you can still see my screen, can you see my screen? Well, you can see me, right? This is the most recent volume of Advances in Industrial and Labor Relations. It was published earlier this year. Volume 26, co-edited by Paul Gollan and me, and it contains some of the papers in this volume are from prior LERA meetings. So if you plan on having us review your papers for publication in AILR, why don't you just let me know that after this session, and we'll follow through with the typical reviewing procedure. So our first presenter is Stacy Cox and Alia Sloan from Michigan State. Perspectives on the hiring process from both employers and applicants with a criminal record. And so why don't you begin?
Okay, thanks, David. Can you see my slides?
Yes.
Okay, great. All
With
right.
the graphics too.
All right, so this is a student of mine who just graduated with her bachelor's degree within the last few weeks, and she conducted this research in connection with a scholarship that she received from our college. And so we're excited to present this paper on the question of whether or not employers should be screening out applicants for employment based on their criminal record. And so the first thing that you may already be aware of is that this is very common for employers to do. They often run background checks. Even our university runs background checks on new hires. And so the idea here is to screen out applicants who may have a criminal record. The problem with that is that that tends to screen out applicants of color and applicants with a disability at a much higher rate than other applicants. And so that's why we're particularly interested in this question. Now, what the research shows is that some employers do consider the type of crime that was committed when they're screening out applicants, but some do not. Some employers simply screen out if you have any felony, any misdemeanor. Some of our employers that hire our master's students screen out for speeding tickets, which means that I would be in trouble myself. There are different levels of screening out people based on their criminal record. The US Census Bureau case is just one example that we discuss in more depth in the paper. The 2010 census was hiring a lot of people to take census data, but they were screening out people based on not just felonies, but also misdemeanors. And they weren't even distinguishing between arrests and convictions. And so that tended to screen out a lot of people who are looking for employment in working for the Census Bureau. And so this is just one example of where even the federal government was using a criminal record to disadvantage applicants. Another interesting piece of this is that there was a study done out of our sister school, we'll call her the University of Michigan, where they looked at the labor market effects of having a criminal record. And what they found was that if people were able to get their criminal record expunged, in other words, removed from their record so that it didn't show up on a background check, that had a significant positive impact, not only on job opportunities, but also on their wages. So from my perspective, I'm an attorney, and so I look at this from a legal perspective. And so I look at it under the disparate impact analysis, which says under the non-discrimination laws that if a hiring practice has a disparate impact on members of a certain group, and that hiring criteria screens out people at a higher level because of their membership in that group, then that's a type of discrimination. And so if that disparate impact is shown, then the employer should have to show that the criteria that's being used is not only related to the job in question that's being filled, but also that criteria is consistent with business necessity. And that's the language that comes from the Supreme Court decisions on this question. And so to the first part of it, it's very clear that screening out based on a criminal record has a disparate impact on people of color because of the higher rates of arrest and higher rates of conviction for members of those groups. And just as an example, the imprisonment rates for African Americans in the United States is 5 times higher than white people. And so that, of course, leads to that disparate impact if they then try to find a job after they've been imprisoned. But this doesn't even count the people who are on probation, who never even serve time in jail or in prison, and yet they have a criminal record. And so employers ask about that record and use that record as a reason to not hire those people. And it's important to note that not all convictions are for, what you would consider to be serious crimes. And many of them are not for any crime that's related to violence. And just as an example, the failure to pay child support is a felony now in many states. And so that can be used to screen out people for employment. Screening out based on a criminal record also has a big impact on people with disabilities because you see from the data that people with disabilities are overrepresented in our prisons and our jails. Oftentimes that's because of a substance abuse addiction, but it's also could be because of mental health issues. As much as 40 to 45% of people in jails and prisons have been diagnosed in the past with mental health issues. So what this means is that if employers are screening out people based on their criminal record, that's going to have a disparate impact, not only on people of color, but also on people with disabilities. So the EEOC in 2012 came out with some guidelines that were intended to reduce this impact of a criminal record on people's hiring. And so they came up with these 3 basic criteria that they wanted employers to use. They wanted them to look at the gravity of the offense. So for example, a a murder should be treated more seriously than a traffic ticket, for example. But also looking at the time since the conviction, because a lot of research shows that after 7 years after a conviction, that person is no more likely to commit a crime than anyone else. And so the EEOC was encouraging employers to think about how long has it been since someone was convicted, and then also thinking about the nature of the job that's being filled. So is that crime that was committed in any way related to the job that the person is seeking? And if it's not, then maybe the employer should not be considering that as a criteria. So these two cases that I wanted to share with you just briefly give examples of where employers did not consider those criteria. So in this first case, an African-American applicant wanted to be a security guard. He had 2 convictions that were 11 and 15 years old, but the court said that employer could still screen that person out based on their criminal record. And then similarly, a very well-known case from Philadelphia was an African-American applicant who wanted to be a SEPTA driver, which is their public transit system. And he had a 30-year-old murder conviction, and yet the court still said that he could be screened out based on that conviction, even though he had no other criminal behavior or even questionable behavior since that 30-year-old conviction. And so what this goes to show you is that employers aren't necessarily following that time rule, in that they're disregarding older convictions.
Stacy, are these examples shown in your slides? Because I'm seeing only your opening slide, and
Oh, geez.
someone has asked, does Stacy present slides? They saw a Google search page, and it's you have about 2 more minutes.
Can you see them now? Can you see my slides now?
Only your opener.
Huh. Well, why is that?
All I see is your Google search, your main landing Google search page. Your slides themselves aren't up on the screen.
Oh, geez. All right, let me try again. Sorry.
Same here.
Sorry about that. All right, how about now?
Yes.
Yep, that's it.
Okay, so I'm going to skip over this slide and give the rest of the time to my student to talk about the study that we did.
You're going to have to do this quickly.
Yep, I will do that. Okay, go ahead, Alia.
All right, so for our findings on the employer perspective, when we asked what aspects of the criminal record do you consider when looking at an applicant, as the graph shows above, certain aspects of the applicant's criminal record appeared to pose a higher concern than others. Nature of crime is the most considered and often the deal breaker depending on the offense. It should be noted that 100% of the employers surveyed understood that they should not deny anyone with a criminal record without more individualized approach. And lastly, that 62% of the respondents indicated that a relationship of job responsibilities to conviction as a bar of employment. For the findings on the criminal record side, we 82% identified as a member of a protected class, and when asked if jail or prison helped with those in the hiring chances, 18% responded with yes. Many of those interviewed showed determination and some form of confidence when talking about obtaining a job, though the majority have been looking for jobs for over several months and have been rejected from multiple jobs. When it came to job offers, 63% have been in a situation where they were offered the job, but the employer subsequently withdrew their offer after learning about their criminal record. Examples of jobs that they were denied were general factory work, restaurant servicing, and stocking jobs. And through examining the responses from both surveys, we noticed a disconnect between employers and criminal record holders' responses. Our research shows criminal record holders are still being denied jobs after an offer. We believe potential bias may be occurring within the open-ended survey questions given to employers, causing the disconnected responses to reality. Though employer responses are indicating that they understand the EEOC's guidelines around criminal records and job relatedness within the hiring process. With this disconnect, we believe employers may be failing to take the requisite second step in ensuring that a criminal background screen is necessary to ensure the success of people they hire. This research emphasizes the need for both employers and courts to consider the business necessity factor before routinely rejecting applicants with a criminal record. These surveys suggest that banning the box on an application may be insufficient to promote the employment of those with a criminal record. if employers are just going to continue to conduct background checks after the hiring process and reject applicants based on their criminal record alone. And then lastly, we conducted this research during COVID-19, and it led to many delays in the research process, cancellations of interviews, and a low response rate than we anticipated. And with such obstacles and time constraint, the data is only preliminary. And this data has created the groundwork for further research to increase awareness around fair chance hiring. And when it comes to the future of our research, we think it's necessary to create a better understanding of issues faced by those with a criminal record. And our next steps for this research are narrowing the survey questions for employers around the EEOC's guidelines and understanding of its implementations within the hiring process. By asking more direct questions, we can see their true comprehension of the guidelines. For the criminal record holder side, our next step is to identify which criminal records are having their offers withdrawn for what position, and to understand if a job relatedness is legitimate concern for the employer. Thank you.
Well, thank you, Alia, and that you moved through that swiftly, but that was helpful. Congratulations to you on doing this research as an undergraduate. We don't see that too often in the association. And maybe you or others might conduct some parallel studies of employer hiring practices having to do with the exclusion of heavy people. Some employers use weight, and others have no smoking rules. And all of this, of course, rests with the property rights theory of employers who, if the practices aren't regulated or denied, then the power to do this rests with the employer. That's the default position. So thank you so much. And let's now move to Rita Trivedi of the National Labor Relations Board, whose paper is titled Consequences of a Mismatch, Remedial Philosophy and Statutory Rights under the NLRA. So Rita, the veritable floor is yours.
Thank you so much. I'll start by saying that this paper and my presentation is just me in my individual capacity, and it doesn't reflect the National Labor Relations Board, the US government. It's entirely my own opinions and my own doing. So
a disclaimer, in other words.
Yes, a disclaimer, absolutely. So having made that disclaimer, my research question when I started this paper was, it's especially with the coming of the PRO Act, it's been bandied about a lot that the remedies available under the National Labor Relations Act are either fall short, unsatisfactory, don't address the harm done to the discriminatees under the Act. And so when I started digging into this, I started to think, why? Why do we have this sort of gnawing sense of dissatisfaction with the remedies involved? And thinking it through, one of the things that came to my mind was trying to figure out what impact does the creation of rights under the National Labor Relations Act and then the remedies that are awarded have on our satisfaction with those remedies. So in other words, is there a lineup between the rights we've created and the remedies that we have to uphold those rights? And if not, what is the consequence? So my paper looks at what I find to be a mismatch between rights and remedies. The National Labor Relations Act, like so many of our anti-discrimination statutes under federal law, creates certain rights for people. It goes beyond what we would think of as a contractual relationship, in that statute establishes that individuals have a right to be free from discrimination on the basis of protected concerted activity, union activity. And then at the same time, we recognize those rights as being something of value to right holders, is the theory that when in, again, anti-discrimination statutes, common law, throughout the legal system generally, having awarded a right, we recognize that right of something of value. And having assigned it that value, we then seek to protect that right. And the means by which we protect that right is usually through some form of enforcement, through remedies, through a way of restoring the individual, and from a way of deterring that violation in the first instance. But with board remedies, we see a disconnect. In board remedies tend to be, as my research paper goes into, more of a contractually based. And again, I'll say that I'm not trying to suggest that board remedies are a matter of contract or that rights are being thought of in that way, just that making an analogy between how we think of the remedies. Board remedies tend to focus a lot more on restoring the status quo. So trying to put the discriminatee back where he or she was before the violation had ever taken place. So we see instances of reinstatement to the workplace in cases of discharge. We see back pay if somebody was denied a certain promotion or a shift or anything like that. We see expungement if somebody had an unlawful warning placed in that file. That warning is then deleted. So it's a lot of trying to reset the button back to where we were. And yet that kind of reset, my paper and my research suggests, is more indicative of what the law generally looks at when parties have made contractual agreements between themselves. So in sort of our common law contract world, if two parties enter into a contract, they can agree on the terms between themselves. If a party breaches the contract, sort of philosophically, as a legal system, we don't tend to look down on them for breaching the contract. We'll certainly provide remedies. We'll require possibly some sort of payment and restoration. But as a normative matter, we don't think that person has violated the other person's right to have that contract carried through. Again, with very limited exceptions, we see specific performance and so forth. Whereas in right-based situations in the law, we do tend to enforce rights. We find value in making sure that a right is not violated. We don't sort of go for a pay or play, that if you are willing to pay the price, you can then get away with breaking that right. And we do this through deterrence. We make sure that the law is not broken in the first place by deterring violators, by imposing certain penalties, costs, consequences for breaking the law. So now coming back to the National Labor Relations Act, we see a lot of restoration without a lot of deterrence. And part of this is due, of course, to the fact that the Supreme Court back in the 1940s limited the board's otherwise statutorily very broad remedial powers to something more of a make-whole in its Republic Steel decision. And my paper and my research examines the consequences of that limitation, taking out the deterrence factor, taking out the prevention, and focusing only on a contractually lensed make whole perspective. And some of my results show that what we have is loss of confidence. And essentially it comes down to both employees, discriminatees, unions, rights holders, because the act does create rights. These right holders come to the conclusion that their rights are not worth the paper it's printed on, essentially, because there is no deterrence of that. And then the right starts to lose value. And when a right starts to lose value, the research paper suggests what we're left with is an unwillingness to exercise that right, because there's a loss of confidence that the legal system will be able to support the consequences should there be discrimination or other unlawful action taken. And in particular, what I found is this is very acute in the organizing context. So when you have employees who are seeking to organize in the first instance, what we have is either through the lure of the shop, having heard of past instances and what happened there, or through their own experience. When they see and go through a start of organizing and activism, and then there's certain responses that are being given to them from management or certain consequences ensue, they realize that what they're left with is rights that they thought they had, but a legal system that doesn't defend those rights in the first instance. So it's sort of akin to saying that you have this very precious object, and rather than putting it in the safe deposit box or making sure you have an alarm system around it, what you've done is you've just left it open and vulnerable to theft. So similarly, statistics of willingness to engage in protected concerted activity, thoughts around the effectiveness of organizing or even trying to exercise rights plummets when employees see that there's a rights-based statutory language and a contractual make whole pay to play kind of remedial scheme work. And by pay to play, I should say that I mean an employer often makes a concerted decision that willingness to violate the law, a knowing violation in the hopes of squelching protected activity, and knowing that, yes, it may have to go before the board, it may have to do some restoration work, but all of that is sort of worth the price because it will have cut off union organizing at the start.
You have a couple more minutes.
Thank you very much. So that sort of price to pay mentality comes with having remedies that, as we see in contractual cases, emphasize that you can't break the required code of conduct if you are willing to pay a price. And many employers, my data suggests, are willing to pay the price because the reward that they receive is having cut down on confidence among employees in their rights and their willingness to exercise their rights. And so long term, for an employer seeking to avoid a union, there's a gain by the chill that's resulted among its employees in organizing. So as I was going through this research and trying to piece together, well, okay, now what? Having found this data and sort of put it through the hopper and seeing what's the consequences of a rights-based language statutory system and contractually based make whole remedial framework, what are we left with? What can we do now? And one of the things that I suggest is that the unwillingness to exercise rights and the lack of confidence is possibly one of the obstacles that needs to be overcome for organizing, as much so as sort of the practicalities of trying to understand what a union can do and having a union movement sort of reinvigorated in the country, is addressing the value that we put on rights as a normative matter and recognizing for rights holders what they can do with those rights and how a legal system can protect them. Again, knowing we are constrained by the Supreme Court's decision in Republic Steel, and if the PRO Act does not pass, as it seems unlikely in this current political climate, that there's some work to be done on the organizing front to address that.
So is your paper available? Is it in the box?
It is currently in the box.
Ah, good. Okay.
It's both accessible in the box, and I think our conference organizers also have set up a Google Drive. So
Yeah.
for those who may have difficulty accessing the box version, it's also on Google Drive under our panel name.
Right. And so if one said that restoration, kind of restorative justice, is ex post, deterrence is ex ante.
Exactly.
That's the way to frame it. A way
Exactly.
to frame it. Yeah.
Yeah.
Thank you so much. And we're going to move on next to Rachel Sederberg's paper, No Longer Qualified, ? Changes in the supply and demand for skills within occupations. Rachel?
Thank you so much. Can everyone hear me?
Yes.
Okay, perfect. Turned off the AC for the occasion. All right, so this is joint work with Mary Burke of the Boston Fed, Alicia Modestino of Northeastern University, who was an advisor of mine during my graduate program, my classmate Shariar Siddiqui, who's now at Amazon, myself and Bledi Tasca, who are both at Burning Glass Technologies, where Bledi is our chief economist, and I am a research lead. So we use the Burning Glass database of 159 million job postings. We examine the changes in employer skill requirements for education and specific skill sets during the Great Recession and subsequent recovery. And we find that there is a persistent trend among high skill occupations and either a temporary or non-existent phenomenon among middle skill and low skill occupations with respect to upskilling. We also find evidence that persistent upskilling in the high skill sector contributed to a greater occupational mismatch that remained elevated during the great recoveries from the Great Recession. And in contrast, the labor market had a largely dissipated the mismatch at the low and middle skill sectors by 2017. So part of our motivation for this paper was to understand changes in employer skill requirements, looking at educational and experience qualifications by employer requirement. We see partially cyclical upskilling an increase in the supply of searchers during the business cycle leads firms to raise the skill requirements, as shown by Alicia and her co-authors in 2016 and 2020. We also see structural upskilling, where the changes in the long run demand for skill due to skills-based technological change and polarization may also increase employer skill requirements. So to the extent that upskilling has been persistent, unemployed workers in some occupations may no longer qualify for the positions that they once held if they lack the necessary education credentials to meet these new hiring requirements. So in our paper, we examine the changes in employer skill requirements for different types of occupations during the period, leading up to and following the Great Recession, to examine the implications for upskilling for labor market functioning, specifically with the possibility of mismatch. Another part of our motivation was trying to understand what happened to the beverage curve. The beverage curve shifted outward starting in June of 09 or so, and remained shifted outward. And so we postulate that we think that sluggish wage growth during the recovery period seems inconsistent with the mismatch hypothesis, but mismatch across occupations returned to pre-recession levels. So that didn't quite fit our story. So we wanted to see what more was going on here. So one potential explanation for the disconnect between the anecdotal evidence from employers saying they can't find workers and the empirical findings from researchers is that there may be persistent upskilling within occupations. And some occupations may have contributed to decreased matching efficiency during the recovery period. So skill mismatch within occupations would reduce matching efficiency if the affected occupations and go largely undetected by existing measures unless the degree of mismatch was sufficiently large or widespread to reduce the aggregate matching efficiency within the entire labor market. Our hypothesis is that one potential explanation for the disconnect between the anecdotal evidence from employers and the empirical finding is that persistent upskilling within occupations contributed to the decreased matching efficiency for the recovery period. And this has some clear predictions. It says that cyclical or temporary upskilling is likely to affect many occupations and lead to a short-term increase in mismatch that resolves quickly as the labor market recovers, where persistent upskilling is likely to only affect certain occupations and lead to a longer-term mismatch that resolves more slowly as workers retrain. So if structural upskilling accelerated during the Great Recession, unemployed workers may no longer qualify for the jobs that they previously held without additional training or skills. This could be seen in technology spaces as well as others. So retraining and skill acquisition takes time and therefore may help to explain why the beverage curve continued to exhibit an elevated vacancy rate relative to the unemployment rate, even though unemployment had fallen back to pre-recession levels by 2017 to 2019. I will note that all of our data, we have not brought in COVID-19 as of yet. That is in the works, but we're not there yet. So for the demand side data, we get our online job vacancy postings from Burning Glass Technologies, where we at Burning Glass scrapes 7 million online job postings from over 40,000 sources daily. From these, we scrape the text and then parse it into skills, education requirements, experience requirements, and the like. We also deduplicate all of these postings so that we are sure that we're getting as representative a view of the data as possible. The postings are also coded by occupation and industry, both using government taxonomies as well as our own proprietary taxonomy. And we can then normalize the data set so that it matches what we find in JOLTS, since we do know that some occupations may be less likely to post online, for example, construction and things like that. So that's the data that we'll be using. We measure whether increases in skill requirements at the 6-digit occupation level were either temporary or persistent upskillers based on changes in educational requirements so that we can match it up with supply side data. And we end up qualifying groups as persistent, temporary, or no upskilling at all. We break out skill sectors into low, middle, and high education or high skill based on the education distribution of incumbent workers prior to the Great Recession. So whatever it was prior to the Great Recession in terms of education requirements is how it stays bucketed. And then we weight upskilling shares by the occupation share of total employment within the sector as of 2006. So is persistent versus temporary upskilling more prevalent in certain skill segments of the labor market? Across all occupations, just shy of 40% qualify as persistent upskillers, where close to 19% were temporary and almost 42% had no upskilling at all. However, persistent upskilling was far more prevalent within the high skill sector as compared to middle skill and low skill groups. So temporary upskilling was most common among middle skill occupations, and no upskilling was most common amongst low skill occupations. But the bigger question becomes, are these requirements binding? Just because employers demand something, it doesn't mean that they'll get it. And indeed, we heard them complain about not finding skilled workers. So using the current population survey, we also show that among new hires within occupations in the high skill sector, the educational distribution shifted upwards relative to existing workers, which suggests that the education requirements imposed by employers in the Great Recession have indeed been binding. And I know I'm coming up on time, so I will move quickly. We looked at changes in required skill clusters within occupations. So at Burning Glass, we break down skills into their skill clusters, and we have the broadest clusters being baseline, specialized, and software skills, with baseline being things like communication, specialized skills being more things like management or something of that form, and then software skills being just that. It might be Microsoft Excel, it might be AutoCAD, what have you. But all three types of skills became more prevalent amongst postings during the recession period for both persistent and temporary upskilling occupations, with no statistically significant differences across any skill group. Across the recovery period, persistent and temporary upskillers continued to increase the share of postings requiring baseline and specialized skills. And by contrast, the share of postings requiring software skills was flat among temporary upskillers, but continued to increase among persistent upskillers. So software skills were the only type of skill for which there was a significant difference in trends over time between persistent and temporary upskilling occupations. So these results suggest that persistent increases in education requirements in the high skill sector may reflect the increased use of technology.
About a minute.
Okay, so we will wrap it up and go to our implications. We've identified one additional plausibly structural factor contributing to the reduced matching efficiency in the aggregate, not detected by previous measures of labor market mismatch. We're looking at employer upskilling within an occupation rather than across occupations. We're thinking that these conditions may account for employers reporting difficulties finding workers with desired skills, while economists found scant evidence for an aggregate labor market mismatch increase. So this made it seem like workers could be chasing a moving target. And with this, we can identify which human capital investments are likely to have higher returns in the long run.
Very good. Education is the variable used to measure skill.
So education is the variable used to measure skill bucket, so to speak. Low skill, middle skill, high skill, yes.
Okay.
And then that's conflated with skills like Microsoft Excel.
Yeah, right. And is your paper available in?
The slides are available in the box, and the paper is available as a working paper from the Boston Fed.
Very good. Thank you so much. And now we're going to. Yes, thank you very much. Now we're going to move to Hyesook Chung, whose paper is Flexible Staffing Practices, Unit Level Turnover, and performance recovery during the COVID-19 pandemic. Hyesook? There we go. Are you on mute? Hyesook? I think you're on mute.
Here you go. Hello?
There we go.
Yes. Okay, great.
Yeah. There you go.
Right. Do you see my screen?
Yes.
Okay, great. Thank you. Okay, thank you for having me today. I'm Hyesook Chung, a PhD candidate from Cornell AILR School. Today, I'd like to talk about flexible staffing practices and their organizational outcomes under the context of the COVID-19 pandemic. Okay, so many organizations, especially in the service sector, often employ flexible staffing practices. So staffing flexibility refers to the ability to increase or decrease the total number of workers in the short term to meet customer demands. Such flexible staffing practices have been widely used because, from employers' perspective, they can help reduce the overall labor costs by matching labor volume to changing demands closely, almost real time or just in time. So they can also allow organizations to respond more quickly to fluctuating market demands. Then how can employers achieve staffing flexibility? They can do it by adjusting employees' schedules by varying their work hours or times from week to week. The use of flexible staffing through variable employee schedules is prevalent in the industry like retail, restaurants, hair salon, and others. And the underlying assumption is that using such flexible staffing practices is beneficial for business outcomes, especially in uncertain environments. With that being said, we know little about whether this assumption is true. So I asked this question: does the use of flexible staffing practices really help a firm, especially in a crisis situation like the pandemic? In fact, there are alternative views from employers' perspectives. Yes, variable work schedules are flexible staffing. But at the same time, from workers' perspective, they could mean precarious work schedules. There have been emerging studies which suggest that these flexible staffing practices can cause various problems like financial insecurity due to fluctuating incomes, health problems like sleep deprivation, inability to hold a secondary job because of reduced predictability in their daily schedules, and finally, reduced ability to care their family members. And these problems are associated with psychological distress and lowered job satisfaction, consequently driving workers to leave their workplace either voluntarily or involuntarily. And prior studies have shown that high employee turnover can lead to lower organizational performance. In short, there are contrasting views about the impact of flexible staffing on business performance. So the goal of this study is to test this relationship. In particular, I hypothesized and tested this model. Flexible staffing can increase employee turnover and as a result, decrease firm performance. Additionally, I argue that the positive relationship between flexible staffing practices and turnover will be stronger during the pandemic. This is because the pandemic has reduced financial and psychological slack for workers to buffer income insecurity and work-life conflicts. Specifically, financial vulnerability can substantially increase. Family members can lose their jobs, and bank loans are more difficult to get. Also, precarious work schedules will give you more burden for employees in terms of work-life conflicts. For example, schools and other social facilities closed, and in-home childcare demands have greatly increased. So here's my model. one thing to note is that in this study for business performance, I focus on performance recovery, profit growth or decrease after the onset of the pandemic. So I wanted to test how the use of flexible staffing practice really help or hinder performance recovery from the crisis. My research setting is restaurant industry, one of the hardest hit by the pandemic. I've collaborated with a prominent restaurant chain in the US, and the stores operate all across the states. I've collected the longitudinal panel data spanning from August 2019 to October 2020, which covers different stages of the COVID-19 pandemic before and after the onset. And across this period, most stores continue to operate with options such as takeout, pickup, delivery, or drive-through. And my final sample is over 18,000 unit month observations from 1,678 units. And these are the measures. I'm not gonna go into so much details, but I have used the variables used in the prior studies and also tried to test with alternative measures. Okay. So this study predicts performance trend across different phases of a discrete event, the outbreak of COVID-19. So I therefore used the discontinuous growth modeling for analysis. As you can see, hypothesis 1 and 2 were supported, meaning that flexible staffing practices were positively related to employee turnover, and this effect was stronger during the pandemic than before pandemic. And this plot shows the relationship. As you can see, red lines which indicate the relationship between flexible staffing practices and turnover during the pandemic are more positive than blue lines, which represent flexible staffing practices and turnover before the pandemic. And I expected that employee turnover will be negatively affect performance recovery during the pandemic. And this prediction was also supported. Performance recovery was more sluggish in stores with higher turnover than those with lower turnover. And finally, I expected that employee turnover will mediate the negative impact of flexible staffing practices on performance recovery during the pandemic. I conducted bootstrapping, and the results show that these negative indirect effects of flexible staffing through turnover are significant. And practitioners often believe that such use of flexible staffing practices benefits business performance. However, my findings suggest that this may not always be the case. And the same HR practices can have different impact on organization outcomes depending on external conditions, in particular normal versus crisis circumstances. And I also contribute the turnover literature by examining turnover as a crucial mechanisms that influences bouncing back from adversity. Thank you.
So
my time is right.
yeah, let me see if we have any questions. I don't see any in the chat. I think you said that unit, meaning store profitability,
yes, stores, yes.
Profitability was the ultimate dependent variable?
Yes, correct.
Right. And turnover mediated the relationship.
Yes.
Your story seems to have the punchline that this particular company with its couple thousand units in the restaurant industry decided to adopt more so-called flexible staffing practices, and that hindered profitability. Mm-hmm. That's the bottom line of your paper.
Right.
Thank you.
Right.
And
Thank
is your paper available in the box or somewhere?
Yes, I think I sent some paper to you, and I will make sure that the paper is available in the box.
Great. Thank you so much. And we're doing okay on time. We're now going to move to David Jacobs' paper, which is aimed at a big topic toward a differentiated model of industrial relations in the United States. So David, why don't you give us your presentation?
Are we freezing? Can you hear me? Are we
Yes, can
freezing?
hear you fine.
Yep.
Okay, great. Thank you very much for David. I'm glad to be here. Thank you for the privilege of being in this panel. I teach business ethics at American University. This is a topic that I've been working on with some colleagues at various times in my personal history, including Ian Robinson at the University of Michigan. And in fact, the University of Michigan was the source of my first insight about the possibility that the states are profoundly different in their workplace governance systems. That is, Sidney Fine, the historian at Michigan, gave a lecture in which he described 1950s Mississippi. It was a very scary picture of a state that had somehow severed itself off from the federal structure and had authoritarian systems for the purpose of discouraging discussion and discrimination. It led me to think that maybe, in fact, crossing state borders can mean something very profound. And I've been thinking about that for a while. I'm going to turn to the PowerPoint now and sharing screen, which is here. Moving along. Okay, so
Don't see it.
I'm talking about what I believe is a differentiated model. Pardon me?
Did you say you put up slides?
I don't see it.
Yeah,
We don't see
I
it.
don't see them. Okay. Okay,
No PowerPoint.
that's curious. Go to back to where it says share slides. Share screen. Oh, I see there. Desktop. I forgot that step.
There you go.
Do you see my desktop now? Okay, great.
Well,
Sorry
it
about
says,
that.
your desktop says launch meeting. No, no, you've got taking a tour. You've got,
Now do you see it? You were screen sharing.
there we go.
Differentiated model.
There we go.
Okay, thank you. Well, so differentiated model. The simplest statement is that maybe the conventional accounts of an internal EU political economy are contradicted by evidence of profound variation in the recognition of workers' rights across the states. This study is kind of an intimate argument, which is set at a number of theories of unity across states and find evidence of disunity of a profound kind. You still can see where I'm going here?
Yes.
Okay, so
Your
first
audio
question is why-
your audio is a
Right.
little in and out, your audio.
Right, okay, well, I'm going to continue under these circumstances.
Yeah.
Why are politicians, journalists, and scholars so eager to emphasize the unity and coherence of US institutions? Why do we always talk about one America? Why did Barack Obama say, this is not the America we know? What does it actually mean in terms of institutions? This is a map of the US of its practices on COVID from 2020. You see that in fact, there are disparate collections of states which initiated very different COVID response systems. And in effect, you see the Western states, you see the Southern states, you see Northeastern and Midwestern states creating compacts and partnerships. And I believe this doesn't reflect actually the values of the people in those states as much as the institutions that provide for representation and reflection of those interests. I mentioned that people are always saying that their America is one version or another, but obviously we have multiple Americas. Looking at the varieties of capitalism model of Soskis and Hull, about a liberal economy, some very interesting claims about that. They say that we have unitary and coherent institutions, that we have labor market institutions that correspond to the economic systems in place, the nature of enterprise, how enterprises are governed, that kind of internal coherence provides for a system distinct from social market capitalism in Europe. John Dunlap stressed consensus and convergence in terms of an industrial relations system. Silly Perlman talked about job consciousness reaching hegemony in the US. Gert Hofstede talks about individualism as dominant in the US. But all of these unitary systems leave something out. Work regulation appears locally and historically differentiated in policy and enterprise. Now, one question that's relevant to all of this is, in fact, is America uniquely individualistic? That's one of the assumptions of Hofstede, is part of liberal market capitalism. And yet we find contradictory evidence. We find widespread and rising support for unionism across the states. We find also broad support for universal health insurance and an increased minimum wage across the states. But I think states differ in responsiveness to these sentiments. I'm not claiming that every state has equal amounts of support for unions. I'm not claiming that every state is equally committed to universal health insurance. But in fact, it isn't the individualism that appears to be dominant that we are told characterizes the US system. So looking at support for unionism, obviously we've all talked about recent surveys that emphasize the rising support for unionism. That's been consistent. I mean, throughout the period for the 1940s, there have been substantial majorities of people interested in unionism, supportive of it, with dips and turns. It appears to be rising now. The MIT Worker Voice study says even in the South, there's rising support for unionism. Freeman and Rogers talked about much unfulfilled support for unionism. It doesn't mean that Southern states are as pro-union as Northern states necessarily, but that there's wide support across the board. The question is how institutions manifest that level of support. Now, the aerial view considers the work of Noah Meltz, who found a very interesting phenomenon of great variance in union density across the states, a ratio of 6:1 in 1990, more than among Canadian provinces. He attributed a substantial measure of this variance to differences in the character of state legislation and political actors, not technology, not industry composition, but something else on the state level. We find even now, despite an overall decline in union density, that the interstate variance has actually increased from 6:1 to 7:1. Now, if we have this substantial support for unionism, we also have this evidence of support for universal health insurance. What I have in the back of my mind is the Webb's definition of labor movement strategies. That is to say, they look at mutual insurance, collective bargaining, and legal enactment. In that context, is it appropriate that we consider support for all of these sorts of phenomena across the states and look at the general levels of interest on the part of the American public? So when you think about legal enactment, when you think about worker support for initiatives along those lines, there's evidence of support for collective activity that is significant. So rather than focusing on a unitaristic perspective on industrial relations, let's abandon the assumption of coherent institutions, assume conflict and competition. Think about the states and the enterprise as they respond to the preferences of citizens and workers. There apparently are nearly incompatible systems of workplace governance with no guaranteed equilibrium or coming convergence. I want to look at particular manifestations of the differences on the ground. That is to say, there is this ocean of support for unionism and support for collective action, but we have institutions which are to varying degrees responsive. As you'll see in terms of the federal constitution, the constitution does not in fact guarantee that every worker has the right to vote. There is tremendous management of voting on the part of the states. And that management of voting, of voter participation, has consequences that differ across the states. Mississippi, Wisconsin, and New York are obviously different in terms of cultures, but the institutions themselves also very strongly shape that phenomenon. So we have the policy gaps. We have historical and spatial differentiation. Remedial, who's an institutional scholar, talks about a complex and protean institutionalism, which makes it possible to distinguish region from region, state from state, city from city, even enterprise from enterprise.
Got about 2 more minutes there, David.
I'm told. Okay, so we have, I want to talk about the disparate systems of labor influence. In a sense, I'm discussing chambers of activity. That is to say, every state with its political system is one chamber. The level of support for labor is reflected in the chamber, but channeled by the institutions. It's an hydraulic system in that the levels of pressure and support change from chamber to chamber. Mississippi, Wisconsin have a set of historical circumstances that generate the degree to which we have representation of people's preferences in the state. Disparate spheres. There's a complete table of what I discover among states in box, but here there's just a little bit, a few states from my table that distinguishes union density, public sector density, the minimum wage, right to work, and Medicaid expansion. We find that states in which we find ordinary private sector unions weak may have significant public sector activity. We find states with neither strong unions in the public or private sector changing the minimum wage based upon the referendum. We have Medicaid expansion happening by virtue of referendum or public pressure. And as a result, it's important to look at each of these categories as a distinct sphere in which labor pressure meets a variety of outcomes and headwinds. I have a way of expressing the sum total of this, which is the various paths by which states arrive at their labor policies within their chambers of distinct labor activity. So the blue states, which are not permanent blue states, tend to have high voter participation, low voter bias in terms of the ability of working class people to participate, at least two well-funded parties, leading businesses that recognize unions, public sector collective bargaining, transparent government practices, and immigrant alliances. Whereas the red states tend to have much lower voter participation, higher vote polarization, short legislative sessions, very powerful employers, and very powerful representation by ALEC, which is the most conservative business lobby that seeks to promote what they call competitive federalism.
Well, David, we're just about out of time. Is your paper available in box?
Yes, it is available in box.
Yeah, great.
Sorry about the internet connection.
No problem. No problem.
The full PowerPoint is there, and a longer version of the PowerPoint.
Right. And I couldn't help thinking as you were talking, I'm probably not alone, that if you looked at a map of COVID vaccination rates, and I've seen these recently, you do find substantial variation among the states.
Right. Yes. And that's, I provided a map of that kind of initially.
Yeah.
Now I'm trying to turn off. I'm trying to turn off my sharing.
Before we conclude, does anybody have any questions for any of our presenters? Now would be a time to do that. Anyone? Well, this has been a challenge, hasn't it? Trying to get enough time for each of you to present, and it's probably not bad practice to have to squeeze something like this into 10 minutes or something less. I'm trying to stop the bell from ringing on my phone. There we go. So it is 10:30 and our session is supposed to end now. So I've been told to stay on time by the powers that be at the LERA, namely Emily and Bernadette. So there we are. Thank you all so much, and hope to see you in some of the remaining sessions in the program. Really appreciate it.
Thank you.
Yep.
Thank you. Thank you
Bye.
so much.
With
Bye,
a
David.
hand wave.
Thank you. Bye,
Thank
David.
you all. Thank you all.
Thank you.